KLK 102.5 FM. Good morning to you. This is Community Conversations. This is our monthly Ask the Attorney segment. We have attorney Mr. Scott Willhite in the studio with us, and we're certainly glad to have Scott with us in the studio today. This is Cato Wonder in the studio with you. I have my co-host with you, Mrs. Quabila Harden, and we are going to get started. I believe Quabila has some general questions, some definitions that Scott is going to answer for us regarding legal matters.
Hi, Mr. Scott. Thank you for joining us today.
Thanks, Quabila, for having me.
And so I know we pretty much put you in the hot seat each time that we have you here. Actually, all these really tough questions. I'm hopefully going to make it a little bit easier for you this time. And I know that most people have a general knowledge of the terminology that is thrown around in the courtroom, but, you know, we're just going to take it a few words at a time and just kind of break them down even further for those that may have family members going through court issues. They may have to file legal documents just so they understand the wording more, so they're not duped into something that is going to cause them more harm in the long run. So I've been looking online. I'm such a Googler.
Well, you know, Cheryl Underwood says go to the Google.
So I'm just going to just throw out some terms, and if you could just break them down, and not to call anyone a dummy. I'm putting myself in this category. So today is going to be basically
legal for dummies.
Legal terminology for dummies, or the Cliff Notes version or something. So, okay. And it's going to alphabetical order because that's just the way it was laid out on this website.
Okay.
We're going to start with acquittal.
Acquittal, that's a term that's used in criminal proceedings, and it basically means the person is determined to be not guilty. The charges are essentially found to be not warranted against the person.
Okay, so
I think that phrase became very popular with Johnny Cochran. You know,
okay.
If the gloves don't fit, you have to acquit. So,
my.
And we definitely need to know those terms as we're in court, that we understand the process. I mean, due process requires us to be treated fairly, have a process that's fair, and so understanding the terms, I think, is essential in that fundamental constitutional requirement.
Okay. Did you have a question or comment?
No, you're the one with the list. So.
Okay. So acquittal means found not guilty.
Correct.
Okay. Admissible.
That's an evidentiary term.
What is an evidentiary term? I guess I know we're kind of backtracking a little bit.
Yeah, let me back up on that. In any trial, there's evidence that is admitted. It might be a document, it might be a statement, it might be a photograph, something of that sort. And before that evidence can be admitted, there are rules that govern the admissibility. There are Arkansas rules of evidence that apply to most situations. For instance, if I tell Quabila I went down to the store the other day, and she wants to testify that Scott said he went to the store the other day in a trial, that might be hearsay.
Okay.
All right. So there are evidentiary rules that apply. And to be admissible means that it is admitted into evidence. It is, there's some indicia of reliability. There's some characteristic about the evidence that means it's probably true. So that's what our evidentiary rules try to do, is keep out evidence that's not true and admit evidence that is. So if it's admissible, there's probably a rule that applies that says, it's sufficiently trustworthy to be in trial.
Okay. All right. Affidavit.
That's a written statement that may be admissible rather than a person showing up and testifying in court. In Arkansas, we use that a lot, say for doctors.
Okay.
It's very difficult to get a doctor to show up at trial. They're very busy. They have a very important job. They need to tend to their patients. So an affidavit may be a statement that the doctor writes out that says, here's my medical records and here's my diagnosis of this person. And so that piece of paper stands in lieu of the doctor's testimony at a hearing or certain proceedings.
Go ahead.
No, I was going to ask, do affidavits have to be notarized?
Yes, ma'am. They generally have to be notarized.
Okay.
We are speaking with local attorney Scott Willhite. This is our monthly Ask the Attorney segment on KLK 102.5 FM Community Conversations, and we are doing just kind of a glossary of legal terms.
All right. right. So the next term, arraignment. We've heard that a lot in the news. Arraignment.
Arraignment is generally one of the first appearances for a person in a criminal proceeding. It's where the formal charges are read and the person is asked, do they understand the nature of the charges against them, the fact that criminal charges have been filed. So it's one of the initial proceedings in a criminal process.
Burden of proof.
All right, now this one's a little more tricky because burden of proof means how sure the evidence has to be against someone for a verdict to be found. And there's different burdens of proof in criminal and civil proceedings. Let's talk about civil proceedings first. Now, civil proceedings are things that are not resulting in a jail term. That might be a personal injury case. It might be a workers' compensation case. It might be a divorce case. Those are all civil. It's where the judge rules that money is going to be awarded or someone is going to be made to do something, divorce or such. The burden of proof in that kind of proceeding is generally the greater weight of the evidence. Okay. It's more likely than not. Maybe you might think of it as 51%. Okay. So that would be a civil proceeding. Now, as opposed to civil, the criminal proceedings, the burden of proof is beyond any reasonable doubt. That's harder to quantify in numbers. I'm not sure if you'd say 90% or 99%, but it's beyond any reasonable doubt. And the reason we do that is a constitutional requirement that people are not convicted unnecessarily or without due process. So it's a higher standard in a criminal proceeding.
Once again, we are speaking with local attorney Scott Willhite. This is our KLEK monthly segment. Ask the Attorney. We are doing legal terms, a glossary of legal terms. This is Community Conversations on KLEK 102.5 FM.
Right. So the next term on the list is capital offense.
Now, my experience in the criminal field is usually limited to misdemeanors and smaller criminal matters. Capital offense, on the other hand, would be something more egregious. It's one of the most serious criminal offenses. For instance, murder. Those kinds of charges fall within the capital offense category.
So if you hear the word capital, that means it's serious.
Yes, ma'am.
And it's going to be more than possibly 10 plus years
Absolutely.
in prison.
Absolutely.
Because I know you hear of capital murder, but are there any other offenses that could have that capital label?
I don't know of any, Leganzi. That's the very first and only offense that I think of when I hear the word capital offense is murder.
I know it's the only one I've ever heard of, but I figured that may be capital rape or something like that.
Never heard any of those terms applied to that kind of charge.
Alrighty. So let's talk. Well, before I get into bankruptcy, we all have heard of bankruptcy, and there are different types. There's like all these different chapters, and I'm not going to have you go through each one, but
well, the two main ones are Chapter 7 and is it 11 or 13? I can't remember.
There's quite a few that were listed. But if you can touch on bankruptcy, and then maybe what are some of the more common ones that people file?
Sure. The most common, I would say, would be Chapter 7, which is an absolute bankruptcy. And let me preface this by saying I don't do bankruptcy work. That's the one area of law that I do not handle, but I did take the class in law school, and I have talked to enough bankruptcy attorneys through my 27 years of practice. Chapter 7 is an absolute filing, meaning you're seeking to, because of your inability generally to pay your bills, you're seeking protection of the law from creditors. And it says you want to wipe out your debts, essentially.
But how does it affect you on the other hand?
Well, it certainly affects your ability to get credit after the bankruptcy. No matter what you do afterwards, you're probably going to be asked, have you filed bankruptcy? If you're going to seek credit or apply for a credit card or any sort of assistance in obtaining any sort of funds.
So from your, talking or your experience with conversations with lawyers that do handle this, how would they properly advise their clients? Would they say, let's work on repairing your credit versus filing bankruptcy? Like, depending on how far in debt they are, how deep in debt they are?
I think that's certainly one of the first options someone should consider. Now, we didn't talk about the Chapter 11 or 13, which are either an individual or a business restructuring. That's still a bankruptcy, but it's a restructuring of the debts where all the creditors would be paid. It would just be paid in a different manner. It might be stretched out in a longer period, but you still have that sort of black cloud hanging over your head that you're in bankruptcy. Now, typically the way it comes into my practice, I do a lot of workers' comp and personal injury, and if you have a workers' compensation claim and you are in bankruptcy, that claim does not belong to you anymore. It belongs to the bankruptcy trustee. So any money that would be generated would go to the trustee, not you first.
Oh my God.
So it affects everything you do during the bankruptcy and afterwards for some period of time.
Once again, we are speaking with local attorney Scott Willhite for our Ask the Attorney segment. We are kind of getting a legal one-on-one course, going through a glossary of legal terms that you may hear even not just in a court proceeding, but throughout your everyday lives. This is Community Conversations on KLAK 102.5 FM.
Okay, now these two terms I'm going to ask together because I receive documentation in the mail from time to time. Someone has filed a class action suit. They filed a claim or something. Claim in class action. Someone has filed, let's just say, Bank of America is one that was recent, several years ago. People were complaining about their overdraft practices, and I recently received notification from another class action suit against another bank for their overdraft fees and things of that nature. So I don't know if these two really go together, but if you can they may sort of go together.
And let me understand, Quabila, the terms claim and class action suit.
Or class action.
And you could probably lump all those together and define them as a class action claim or suit is a method of resolving a wrong done by one business or individual that affects many people. So that there's really too many people involved to individually file suit. It may be difficult. Let's just say you had, in the instance you mentioned, a bank that charged a fee that was improper to 1,000 people. It would be difficult for all 1,000 to come in and file an individual suit in a court. It'd be hard for the people. It'd be hard for the court. It would just make it difficult in time and expense. But a class action says one of those 1,000 can be appointed to be a class representative and seek damages for the entire group as long as the wrong done to them is the same. So it's just a method of resolving claims that involve a great number of people that are making the claim.
All right, so the claim is basically you're saying someone did you wrong. And is that what a claim?
Yes, ma'am.
Okay. And then a class action involves a group of people. So
yes.
I'm going to say that I have benefited from, and I'm grateful that someone stepped up. I have received some back payments on some things in the past. So I'm not to say that, I'm looking forward to that. I don't want to be done wrong, but I'm thankful for those people that did take action to file those class action suits. Okay, and you've already explained due process. Just a matter of making sure that the person's rights are recognized, they're handled properly. I'm sorry.
Well, the 14th Amendment applies it to the states, so we have to remember that due process is basically a guarantee for each individual that before life, liberty, or property can be taken from them, there has to be a fair process that is given to them. I can't come and take your car if I'm the financing agency unless I have some process that is fair that is applied in that circumstance.
Okay. The next term, like I said, these are just in alphabetical order because I just picked a few off of the website. Grand jury.
A grand jury is one method of determining if charges should be filed. Different states have processes. Sometimes we use the term prosecutorial discretion, where a prosecutor decides if charges are going to be filed. In really large, difficult issues, a grand jury might be convened, where people are called in and a sort of a snippet of the evidence is presented to that grand jury, just a group of people,
Okay.
and they determine should charges be filed in that circumstance.
Okay. Habeas corpus.
That's really a body attachment. I can remember
Okay.
it brings back good memories. My granddad was a real character, and when I was in law school, I would come home and he would sit down at the table. We would eat dinner, and he would say, "How's your habeas corpus?" It's a body attachment. It's where the court reaches out and says, "You, Mr. So and So, are going to be in my court.
Okay.
Your presence is required."
So it's almost like a summons.
It is
Similar to a summons.
Yeah, similar.
Okay. An injunction.
An injunction is an order of the court telling a person or a group of people or a business either to do or not to do something.
Okay.
It may be don't conduct business in that manner.
Okay.
Something of that sort.
Okay.
Once again, we are speaking with local attorney Scott Willhite on KLK 102.5 FM. This is our monthly Ask the Attorney segment on Community Conversations.
And I hope I don't screw this word up. It starts with a J. Jurisprudence?
Jurisprudence is relating to the law.
Okay.
It's just a term that it just signifies something relating to the law.
Okay. And can I just say, intervene here, Mr. Scott is doing all this off the top of his head. So that goes to show how dedicated he is to the law and to his practice. He's not Googling anything. So I am so
Well,
impressed.
after 27 years, I would think you would have it down pat.
You're stretching my ability, though, Kabila, I tell you.
All right. I might have to buy you dinner one day. All right. So a lien.
A lien, and it may be best to describe this with a scenario.
Okay.
Sometimes, let's just say you have and because I do workers' comp, this is the issue I deal with a lot. Let's say you have a workers' comp claim, and the employer denies the claim, saying we're not responsible, and you have to get your health insurance company to pay your medical bills.
Okay.
Well, if you then proceed in your workers' comp claim and you win, and your workers' comp insurance carrier is going to have to pay you, the health carrier would have a lien. That means they have paid medical bills or paid bills they shouldn't have had to pay.
Okay.
And they may have a claim against your workers' comp suit.
Ooh.
And they may be able to get some of their money back.
So a lien is almost like you're getting something, but I want a piece of that.
Yes, ma'am. That's exactly what it is.
Well,
I'm
Scott,
entitled to something.
Well, Scott, maybe for people who may not know what workers' comp is, use the example because I know this is something that probably everyone deal with, like with a car. When you buy a car, the bank puts a lien on the car. If you don't, well, I'll just let you explain. You kind of know where I'm going with.
Sure. If you purchase a car and you finance it, the bank has a lien, meaning they own essentially the car. It's not really yours, even though you call it your car and you're paying for it. The bank really owns the right to it. And if you quit paying, that lien says they have a right to do something. It generally says they have a right to come and pick it up.
And that's basically how you get a repo.
A repossession, that's right.
All right. All right. The next term is litigation.
That means something to do with court proceeding.
Okay.
That's when you go to court and you get something heard by a judge or a jury.
Okay. Mistrial.
A mistrial is a right a judge has to declare that a proceeding is not fair and it's got to stop.
Okay.
So if there's something strange or unusual that happens in a trial, a judge can say, I'm declaring a mistrial, meaning we're going to stop these proceedings. We're going to have to start all over at another time.
Now, once a mistrial has been declared, can the prosecutor or whoever was not in favor of the mistrial, can they come back and present more evidence and say, okay, can we try this again? Can a mistrial be tried again?
Absolutely.
Okay.
Generally, that's what happens is in a criminal proceeding, the prosecutor determines, is he going to go forward again? And they make that decision, and usually they decide if they have evidence, they will. Or at a civil case, the parties request another date, and they present whatever evidence they have as of that date.
Okay.
All right, we're going to go ahead and leave it there. We got to get ready to go to break. This is Community Conversations on KLK 102.5 FM. We are speaking with local attorney Scott Willhite, going through some legal terms. We'll be back. This is KLK 102.5 FM. KLK 102.5 FM, and we're back on Community Conversations. Our special guest is Mr. Scott Willhite, a local attorney. We are doing our monthly Ask the Attorney segment, and this month we're doing something a little different. We're kind of going through a glossary of legal terms, and in our last segment we went through several terms, and it's definitely been very educational, and we certainly appreciate Scott for taking the time to share the definitions of these terms with our listeners. So let's go ahead and get back into our list.
Alrighty, so I hope everyone is enjoying this. I just wanted to do this because you see so much on TV. You might get some paperwork in the mail. You might have to file something paperwork yourself or go to court for some reason. So it's great to be educated so you're not duped into something that you didn't know what you were getting into. So, okay, I want to ask another term. We were talking about mistrial before the break, and so I've seen the term also double jeopardy. And of course, there's a movie about double jeopardy, but can you explain, what that means?
Sure. That's a constitutional requirement. You can't be tried for the same crime twice.
Now, is it with the same evidence or you just twice, period?
Just twice, period.
Oh, wow.
So if you are acquitted and more evidence is found, generally they can't come back and retry you. What? So it makes the prosecutor's job, difficult as far as timing to make sure they have everything they need to move forward.
So what if, I'm sure this has happened somewhere down the line, the person goes to trial, they're acquitted. Well, the criminal, the person that was charged, they might confess that they actually did what they were charged with, but they've been, set free. They can't be tried again for it.
I don't know of a way that they could be under that circumstance.
And that would probably fall under the hearsay or client privilege.
There are exceptions to hearsay, and I should have explained that earlier, but if a person is a party to a lawsuit, for instance, if you're suing me and Leganzi hears you say something and wants to testify that Quabila said something, he can do that because you're a party to the suit. That's an exception. But if you were not a party to the suit, then he generally couldn't testify as to what you said.
Oh, wow. So people are finding ways to get around the system and making it work for them. And because I know there are a lot of people that are upset all around the world. Why didn't this person go to jail? How did they get off? They found some loophole to help get them out. Right,
and we have specific rules of evidence and specific rules of criminal procedure and rules of civil procedure that they govern the way trials operate.
Okay.
And if they say something should happen, even if it appears to the public, it should be handled in a different way.
Okay.
It just doesn't happen the way the public wants for that reason many times.
Okay. Wow.
All right, so what's the next term?
All right, the next term
Or do you need to pause for a moment and let your head...
No, I'm good.
You look like your head's about to explode.
I mean, even though law is not my initial, it's not really a field of... It's a field of interest, but not at your level. But anyway, I'm good. The next term is motion.
A motion is generally a piece of paper that is filed with the court that asks for certain things to be done. A motion for a new trial. Say, for instance, if you feel that the trial was unfair and a jury comes back with a verdict that you don't like, you can file a motion for a new trial. Or you can file a motion, say, in a criminal proceeding, if you don't think evidence should be admitted against you, a motion to exclude certain evidence.
Okay. I bet there's a lot of paperwork floating around the courtroom.
Pretrial motions are very common. They're actually dates that judges set that are cutoff dates that you have to file your motions by a certain date or they won't hear them, just to make things more efficient.
Okay. The next terms, and these two kind of go hand in hand or they interrelate, parole and probation.
Well, probation is a criminal sentence that does not involve jail time.
Okay.
And it allows a person primarily to have a chance to serve some sort of sentence without going to jail.
Okay.
It can be it might be for 3 years or 5 years, but they have to report to a probation officer.
Okay.
A parole is something, it's a requirement that someone has after they are sentenced to prison. They report to a parole officer upon their release to make sure they're complying with whatever requirements they're sentenced to.
Okay. And a plea.
A plea is a statement to the court. For instance, if you get charged with, let's say you're caught speeding,
Okay.
all right, and you have a court date, you have to appear in court on a certain Tuesday at 1 o'clock down here in district court, and you have to enter a plea. You either say I'm guilty or I'm not guilty. Right? If you say I'm not guilty, then you get a trial date. But that's the plea, is the statement to the court as to your guilt or innocence.
Okay.
Once again, we are speaking with local attorney Scott Willhite. This is our KLK Monthly Ask the Attorney segment. We are doing legal terms. This is Community Conversations on KLK 102.5 FM.
Now I want to ask this, and I don't know how much experience you've had with this particular thing. Okay. Someone gets a speeding ticket. We're just going to take speeding tickets or no proof of insurance. We know those can be quite costly. I've had a few in my day. They're over $300 for no proof of insurance. So anyway, someone like me doesn't make a lot of money, goes to court. I say I'm guilty. Oh, by the way, you have to pay a down payment of XYZ. Well, I don't have that today. Okay, well then you go to jail and it's paper for release. Where someone that does something, break into a house, they go to jail, they get a bail. They're able to get to bond out of jail. So I don't know if you can explain why it's like some people are able to bond out, some people are paper for release. Like, I don't know.
Or what the difference is.
Sure. Let's talk specifically about the bail or bond.
Okay.
They're the same thing, bail or bond. That is a pretrial release term.
Okay.
That means before you go to trial, the court has to determine the likelihood of you showing up for trial.
Okay.
And they're supposed to set a bond or bail that will require you to show up at trial. And so if you have a very minor offense, it might be on your own recognizance that they trust you to show up because it might be just a traffic ticket.
Okay.
That's typically the bond on a traffic ticket is, they give you the ticket and they require you to show up.
Yeah.
If you had a serious offense, a murder, a rape, or something of that sort, you might have a bond of $100,000 or more because you would have to post some amount of money or go through a bondsman to take care of that to make sure you were going to show up at trial if you were released from jail before the trial. The second term you're talking about, pay before release, is something that happens after your conviction.
Okay.
And so that's what the court sets as a release term. You either do jail, say you do 5 days of jail, or you pay $1,000.
Yeah.
But the court here typically requires a 25% payment.
Okay.
And that is a sort of a problematic issue. What if you don't have the money? Do we sentence people to jail for not having enough money in their bank account? That's always been an issue in the back of my mind is can the courts require you to pay a certain amount or go to jail?
Yes, and I know this is something we face because you ran for a position, some time ago. We won't get too deep into that right now, but, you were wanting to make some changes with the system and, maybe we'll see you again somewhere down the line. So,
maybe so.
We never
Maybe
know.
So.
Okay, so I have my own feelings about the court system. I love
Well,
it.
don't turn it to political because then I'll have to give a disclaimer.
No, we're not going to go there. So, okay, we're going to move along. So,
And once again, we are speaking with local attorney Scott Willhite. This is our Ask the Attorney segment on KLK 102.5 FM. You're listening to Community Conversations.
all right, so the next term on the list is remand.
A remand is an order, of one court that sends the case back down to a lower court. For instance, if you had a case in circuit court and the circuit court made a decision and it was appealed to the Court of Appeals, the Court of Appeals would then consider that decision, and if they thought an error had occurred, they would remand the case or send it back down to the circuit court for the circuit court to pay attention or to do what the Court of Appeals mandated or told them to.
Okay. Alrighty. Sanction.
A sanction is just a penalty. It's a requirement of the court because of certain behavior. They may sanction an attorney for acting out in court, and they may penalize him and charge him some money or say you've got to be on probation for 6 months or something of that sort. It's just a penalty.
Has there ever been an attorney that was so badly sanctioned that the attorney himself was thrown in jail?
Oh, I'm sure under a contempt charge, lots of attorneys have been thrown in jail, but I haven't I haven't known any firsthand.
Okay, and you mentioned the word contempt.
Yeah. Can you go?
So define that.
That's a willful violation of a court order.
Oh, wow.
All right, so you can have anyone who's associated with the court proceeding could be held in contempt. It happens a lot of times in domestic situations where parents are divorced and one parent thinks the other parent's doing something wrong, so they will petition the court to hold the other one in contempt. Okay. If they fail to provide adequate visitation or child support or various circumstances.
Okay. And I maybe should have asked this one earlier. I know, like I said, these were in alphabetical order, but a plaintiff.
A plaintiff is the moving party. For instance, if you are in an auto accident and you're hurt, you would be the plaintiff in a lawsuit if you filed one against the other driver. So
on the flip side, what is the defendant?
Well, the defendant is the responding party in a civil or criminal lawsuit. Many times it can be the state of Arkansas, the person charged with a crime in a civil matter, or it can be the person who maybe caused fault in a civil matter and who's being sued.
Okay, so that's the defendant. Okay.
Right.
And then this term I've heard before, precedent or precedent? Precedent.
A precedent is just a ruling of the court. It's a decision or a ruling of the court.
Okay. Alrighty. The next term, which most people should know what this is, sentence. And we've talked a little bit about this before as far as what sentence someone receives is based upon the crime and then the different levels of... You brought a chart once.
Right, and we have a presumptive sentence based on the seriousness level of a crime.
Okay.
And that sentence is just the order of the court as to that person and their penalty.
Okay. And then we also talked about, which is kind of it can get to be a heated topic when you talk about types of sentencing or level of sentencing or basically amount of time someone receives. We talked about, different states have different levels of sentencing,
even different laws.
Yes.
Each state has different laws.
It can be a little annoying or frustrating for the parties and families involved. And this probably doesn't tie into sentencing, but it just came to my mind. Someone commits a crime. They live in Arkansas. Their address in Arkansas, born, whatever. They commit a crime in North Dakota. They tried it there, or where are they tried? What happens then?
In a criminal matter, the charge will be filed where it happens.
Okay.
Where it occurs. Civil matters are a little different.
Okay.
You have various statutes that apply to civil matters, so they can be brought sometimes in states where the defendant or the allegedly guilty party has a operation or a business or lives, but a criminal matter generally is going to be filed where the act happened.
Okay,
right.
And then verdict kind of goes along. It precedes a sentence.
Well, a
verdict.
It's the decision of the jury or judge based on the evidence.
Okay.
A verdict. For instance, if you have a personal injury suit and you try it to a jury, a 12-person jury, at the end of the case, the judge will ask the foreman of the jury to read the verdict, and that means to tell everyone involved what their decision is. They may say, we find the defendant negligent and he's got to pay so much money, or they may say, no, we find him not negligent.
All right, once again, we're speaking with local attorney Scott Willhite. This is our Ask the Attorney segment. You mentioned the term jury foreman. Who is the jury foreman?
Well, anytime you have a jury, there has to be a decision before they make any final decisions as to who will be the leader and sort of lead the discussions, who will speak to the judge on their behalf. And generally there's a vote among the jurors as to who will be the leader or the foreman.
Okay.
So during deliberations, the foreman would be the one that would ask, do a roll call or however they make decisions, however the jury comes to a decision on guilt or innocence.
Correct. That would be the one that corresponds with the bailiff or the judge, and then takes that information back to the jury and gets the written information that the judge needs to make a decision in the case.
how is that person? I'm sorry if I missed. How is that person chosen?
It's just by a vote of the jurors.
Oh, okay. So they collect.
I guess they meet. I think they get amongst themselves and say, "Okay, who wants to be the jury foreman?" And I guess somebody can raise their hand and say, "Okay, well, you're it." Or I guess if a couple people spoke up, I guess they could vote, and whoever gets the most votes wins.
And understand this, guys. I've probably 20 or 30 jury trials over my 27 years, but I've never sat in a jury while they're deliberating. That's something attorneys don't get to do. So,
yeah, I guess being an attorney, you probably wouldn't be asked to be on a jury. Probably get thrown out.
Right. I've been excluded from several times that I've been called for jury duty.
Wow. Well, another term that goes along with that is sequester.
Sequester means to sort of set aside and not allow those jurors to be in the presence of other people. So they close the doors, lock the doors, and make them stay in a certain place so that hopefully they make a decision. Sometimes the jury goes days or weeks without making a decision. They're deliberating. They're trying to figure out the evidence. And if you sequester them, you put them by themselves and take the food to them and don't let them out.
That was going to be my
Lock
question.
them up.
That was going to be my question. If a jury is sequestered, is it required that they bring them food and water and allow them to use the bathroom and stuff like that?
I think generally they are taken care of as far as all the necessary things that a person would need. They're allowed to go home and go to sleep. They come back in the morning and they're fed, and hopefully everything is provided for them they need, and they make a decision.
In what types of cases would you see where the jury is put up in a hotel or a motel? They're totally isolated, no cell phones, no TV, no newspaper.
Probably one that is very exciting to the media.
Okay.
So a judge may not want those jurors to be subjected to media attention, reporters asking questions, or even watching the news. It may be such a hot topic case that the judge just says, I can't take the chance of that juror hearing a news report.
Okay. Another question, kind of switching gears, is statute of limitations.
That's a rule of law that limits the amount of time you have to bring a claim.
Okay.
Generally, like a personal injury claim has a 3-year statute of limitations. So if you don't do something in court or settle your personal injury claim in 3 years, you don't have any more rights.
Okay. And then
Excuse me.
we talked about this, and I think it goes along with another term, subpoena.
That's a directive or an order of the court directing that either information or a person show up for purposes of gaining information. It may be a directive for a person to show up in court and testify, or to bring certain documents that are relevant. But it's an order for someone to appear and possibly bring information with them.
Okay. And then other common terms that we hear, testimony, we all know what that is. Transcript is just a written document of what's going on, word for word. I want to ask about the court reporters. They have this little machine. They have to learn shorthand? How does it work?
Well, some of the, some of the more experienced court reporters may still use shorthand.
Okay.
But many of the court reporters now speak into a microphone that records the information, and they type it up at a later time. The more recent court reporters that the more technologically advanced court reporters may even have a real-time program that as they type what they hear you say, it puts it on in digital format so they can just print it out later. But the court reporters, take down everything that's said, as you mentioned. It might be a deposition where you go and ask people questions. It may be a trial where they're taking down testimony and information. But essentially, they have to take what they hear and type it up into a format that's a little booklet called a transcript.
All right, we are speaking with local attorney Scott Willhite. This is our Ask the Attorney segment. We're going to get ready to go into break, but we will be right back with more on Community Conversations. This is KLEK 102.5 FM. KLEK 102.5 FM, and we're back on Community Conversations. This is our monthly Ask the Attorney segment. Kato Wonder is in the studio with you, along with my co-host, Mrs. Kubila Harden, and then we have Mr. Scott Willhite, a local attorney, who is answering questions about legal terms that we have. So what other terms do you have for us in this final segment?
All right, so we pretty much gone through the alphabet. Some of them were kind of, I'm going to say self-explanatory, but some of them don't apply to everybody. So I don't want to drown people in a bunch of terminology, but I just want to highlight some ones that we hear that we may not fully understand sometimes. Like there's another one, standard of proof.
That's going to be similar to the burden of proof, just the level of proof required.
Okay. And we were going back and forth over this one word. It's a French term, and I'm not even going to dare try to say it.
Voir dire. Or voir dire. It's when the jurors are questioned before the trial to determine if they're going to be truthful and do what the judge tells them. It's just a time for the lawyers to ask the potential jurors questions. Okay.
And I'm surprised someone here in America hasn't decided to change that terminology to something that everyone can say. We're bad about that sometimes. We want to change things to fit us, make it easier for us.
Well, Scott, isn't there a lot of Latin terminology in the law?
I think Latin is a big part of the law in America. As we get further and further into our time, it becomes less and less used.
Okay.
But older lawyers, I think
they still use some of those.
They still use some of those, but I don't think all judges call it voir dire or voir dire anymore. They may say you're allowed to question the potential jurors.
Okay. Right. Like another one that's you said that was a Latin term. Similar, writ of
certiorari.
Certiorari, because my southern self says cert.
What that is, Kobila, is it's a review of a lower court ruling by a higher court.
Okay.
So it's just the lower court sends an issue up for the higher court. Say, for instance, the federal court sends something to the U.S. Supreme Court to decide before they continue on.
Okay. I must say I've truly enjoyed having you here and going through some of these terms. Like I said, I don't aspire to be a lawyer, but I like to dibble and dab in various topics and just educate myself as much as possible. I never know when this stuff is going to come up, when I'm going to need to pull from a bank of knowledge. And,
anytime we go to court, we want to be treated fairly. Mm-hmm. That we, as humans, we expect to be treated with a certain amount of dignity and courtesy, and our Constitution requires that. So what we want to do is we want people to understand that when you get in court, things move quickly, and if you don't understand the terms that are being used, you're at a great disadvantage.
And I've seen that, people go to court over traffic tickets. I must say my first one was when I was 19. I went to court. I was like, what just happened? What just said? And the judge is not going to really repeat what he said. And the bailiff is kind of standing there with his look on his face. He wants to laugh at you, kind of, but he refrains, or she, whoever's up there at the point. The clerk, they are too busy writing notes and whatever, so they can't backtrack and tell you exactly. They'll just say, well, ask the jailer later, ask whoever later.
And then it's maybe too late.
Yes. I found myself in some of those situations where it was too late. So, are there any other things that you would like to highlight that I know that we haven't talked about?
Well, we've talked about some of these things in prior meetings, but just a guilty plea, a no contest plea is something that most people probably should understand before they go down to district court if they have a traffic ticket or some minor violation, that there are different ways to respond to the judge as far as your initial appearance, whether you plead not guilty, or no contest. There are different consequences for each one. So understanding the different consequences is essential before you go into court.
And for those who may not have ever heard one of these segments before, could you give a brief overview of each one?
Sure. If you feel that you do not want to oppose a charge, obviously you would plead guilty, and the court would sentence you. On the other hand, if you feel you absolutely did not do the things that are charged, you would plead not guilty, and you would get a trial date at a later time.
Okay.
The no contest plea is sort of a interim plea that you get to sort of explain maybe why you did what you did, but you don't think you should be sentenced as harshly as maybe a typical judge would rule against you. So sometimes we use a no contest plea to allow someone to get a sentence where the facts just don't warrant the typical treatment.
Okay, and I do have one question now that I'm thinking and listening to you talk. If someone has a lawyer working for them in a particular case, they may not understand all of the fine details of the case and how the proceedings work in court. Does the person have a right to challenge their lawyer? Now, we've talked about before how lawyers are super busy. You have paperwork you have to file. You have a bunch of things you have to do before you even step into the courtroom. Does I'm guessing plaintiff, would that be the right? Well, not necessarily. The person you're representing, and they have the right to question you or say, I did my own research and here's some things that I found. Can you check this out? Or is this even plausible to our case? Or does the person have a right to challenge the lawyer to dig deeper?
Sure. I mean, I think that conversation needs to take place in private between the client and the attorney before they go into court to determine the viability of any sort of theories like that. But absolutely.
And piggybacking off of that, could you define attorney-client privilege?
Sure. Anything that an attorney talks with his client about in private is protected. It cannot be discussed by the attorney. Now, the client can talk about it to anyone he wants. He can disclose that information, but the attorney is prohibited from talking about that information to a third party. Unless if there's another person in the room that hears it, that may disqualify that from protection. But generally, that conversation is protected between the client and the attorney.
Oh, go ahead.
I just have one quick question. And I know we talked about, again, how these TV shows have blurred the lines and, what really happens in a courtroom. But I love Law and Order. And a lot of those shows, you see the prosecutor and the defense attorneys having little one-on-one meetings without the client. One, is that supposed to happen? Is it, okay? Two, is the attorney responsible for telling the client what happened during that meeting? Like, they're trying to make these backdoor deals sometimes.
Well, there's always contact between the prosecutor and the defense attorney about various issues. It could be motions, it could be certain aspects of a trial or positions, and evidence, things of that sort. But yes, those meetings take place. They take place all the time.
Okay.
Anytime I represent a defendant in court, I have to talk to the prosecutor without my client being there. But then the second question was, does that information then have to be disclosed to the client? And then the answer is yes. Okay. There has to be some accurate representation of that conversation presented to the client, especially if it's going to involve any sort of plea agreement or an important decision.
Okay. All right. Well, Scott, we certainly thank you for your time. We're just about out of time. This is Community Conversations. Our guest for today has been local attorney Scott Willhite, and we hopefully have educated you on some legal terms that you may matter. We do this each and every month, I believe. What do we do this, Steve?
Usually it's on the first part of the month, the first or second week of the month, but Mr. Scott has been super duper busy.
And we had elections too.
Yeah, so we'll be back on the regular schedule starting in December, and of course we will post this on our social media. So Scott, once again, thank you for stopping by, and
thank you.
May each and one of you have a great and blessed day. This is KLEK 102.5 FM.
Thank you for listening to Community Conversations on KLEK 102.5 FM, a program focusing on the people working to make the Jonesboro community a better place while offering viewpoints from all sides of the issues. The views expressed in this program are those of the participants and do not necessarily reflect the views of KLEK 102.5 FM, the voice of Arkansas Minority Advocacy Council, or our underwriters or sponsors.